Hi folks, Dave Waring here again with FitSmallBusiness.com and today's lesson of the day. In our last video, we continued our series on how to start a successful business with a look at how to choose a legal structure for your business. In today's video, we're going to continue that series with a look at how to know whether you need patents and trademarks for your business. So let's get started. Because both patents and trademarks are designed to provide certain protections for businesses, they're often confused with one another. The difference, however, is pretty clear. Patents are used to protect an invention from being produced by other parties. In addition to a product, an invention could also be a process for doing something. Patents expire after 20 years. Trademarks, on the other hand, are used to protect words, phrases, symbols, and/or designs that distinguish goods as coming from one company instead of another. Popular uses of trademarks are to protect company names, logos, and slogans. Trademarks do not expire as long as they are used, and their registration is kept up to date. On March 16th of 2013, a new law was put into effect, which dramatically changed the way that patents are handled. Prior to that date, the United States operated under a first-to-invent system. This meant that if you could prove that you were the first to invent something, that it didn't matter if someone else held the patent, it became yours from that point on. On March 16, 2013, the U.S. switched to a first-to-file system. This means that the patent belongs to whomever was the first to file the patent, regardless of who originally invented it. This brought the U.S. closer in line with how the rest of the world handles patents. Can someone patent your invention once you make it public? No. Once the invention has been disclosed to the public, it cannot be patented, with one exception. Under the new law, the inventor has a 1-year grace period after making the idea public to file the patent, after which point they will be unable to file a patent as well. Keep in mind, however, that if you do make your idea public before filing for a patent, then this will negate your ability to obtain a patent in most other places in the world. Getting a patent is expensive, and quality matters. If you had 10 different attorneys draw up patent applications for the same invention, you are going to get 10 different applications. For this reason, the quality of the attorney that you use can make a huge difference in whether or not your patent has any value at all. Also for this reason, a quality patent application is going to cost somewhere between $10,000 and $25,000, and patents from cheaper online and do-it-yourself services are likely to be worthless. When should you get a patent? More times than not, the effort and expense required to obtain a patent is going to outweigh their benefit. Even if you do obtain a patent, if someone breaches your patent, you still have to go to court to defend it, where costs can run into the hundreds of thousands of dollars. This makes patents much more useful to large corporations than they are to startups. With the above in mind, here are a few general guidelines for deciding if you need a patent. Is your idea commercially viable? If your invention won't sell, then it really doesn't matter if you have a patent or not. Find out if it will sell first by watching our 3 steps to testing a business idea video. Are you going to run with it? Some people invent things with the hope that they can sell it to a large company who will produce and sell the idea. This is a low-odds venture, and if you don't have the high-level contacts within the industry, you're unlikely to even get the first meeting. Scope. The Patent Office has gotten very defensive about granting patents that are broad in scope. So, for example, if you came up with the idea for the online shopping cart, it is unlikely that you would have been able to get a patent for this idea. If, on the other hand, you came up with a very specific process for how your online shopping cart works, then this may be patentable. Trademarks are more straightforward and less complicated than patents. As we discussed in our video on how to name a business, you definitely want to search and make sure that no one already has trademarked the name you're considering using. Should you get a trademark? In order for someone to win a trademark case, they must prove that you are using their business name, logo, slogan, or other trademark in a manner that is likely to confuse customers. If your business is named Bob's Plumbing and operates locally in North Carolina, then it likely will not matter that Bob's Plumbing, who operates locally in NYC, has a trademark. However, if Bob's Plumbing is a national brand, then you may have a problem. With this in mind, here are some general guidelines as to when you should obtain a trademark. If you plan on doing business locally, then the costs of trademarking your business name, logo, and/or slogan are likely going to outweigh the benefits. If you plan on operating on a large scale, both in your state and nationally, then you will likely want to obtain a trademark. I've included a link below this video with a list of other resources to help you decide if you should obtain a patent and/or trademark, as well as how to go about filing for each. That's our lesson for today. If you have any questions or comments, please feel free to leave them in the comments section below. Also be sure to stay tuned for the next video in this series on how to start a business, where we will discuss business plans. For more great advice on how to start and run a successful business, be sure to visit us at fitsmallbusiness.com today. Thanks for watching.